Welcome to my channel, where we discuss everything and all things politics, economy, and development in Nigeria and around the world. A Lagos-based lawyer has faulted Governor Sanwo-Olu of Lagos State over alleged 200 million naira legal fees that he paid to lawyers that represented him at the election petition tribunal and at the various stages of the courts that the election petition had taken him. Now, this Lagos lawyer is Festus Ajim. He has criticized Governor Babajide Sanwo-Olu for approving the payment of 200 million naira to 4 law firms that defended him in the suit filed by the People's Democratic Party against the Independent National Electoral Commission and 42 others. In a document that was published on the website of the Lagos State Procurement Agency, tagged Letter of Award, registered for January 2023, the sum of 50 million naira each was awarded to 4 law firms designated as contractors. The law firms are Ahmed Raji & Co., Akimboro & Co., Babatunde Ogala & Co., and Messiah's Femi Okunu & Co. The award under the Lagos State Ministry of Justice was described as instruction to represent and defend Mr. Sanwo-Olu Babajide Olusola in suit number FHC/CS/1979/2022 PDP versus INEC and 42 others. Barrister Ogun said paying the lawyers with taxpayers' money was not acceptable. Say paying the lawyers with taxpayers' money was unacceptable, even though the lawyers deserved to be paid the amount. The human rights lawyer said, in quote now, "Lawyers have to be paid. My concern is not about how much they paid them or why they should be paid. My concern is not even about the lawyers. The suit was instituted against Sanwo-Olu as a person, not in connection with any of his roles as a governor. So if the lawyers are to be paid, they ought to be paid from the Sanwo-Olu purse or any other purse, but not from the treasury of Lagos State." Now, this lawyer insisted that it is an abuse of office and unconstitutional what Babajide Sanwo-Olu did. Now, this is very important. Why is it important? Because Sanwo-Olu is the one that we have seen his own matter. Like they say in local parlance, the breeze has blown and we have seen the nyash of the fowl. But it goes beyond that. Do you know how President Bola Ahmed Tinubu paid his own? You will not know it because it was not exposed how he paid his own. Did President Bola Ahmed Tinubu pay his lawyers, the array of lawyers that represented him, both in Nigeria and the United States? Did he pay with his personal money? We may never know, because unlike Sanwo-Olu, the procurement of the federal government did not say anything. Nobody has revealed anything about how Tinubu paid for his legal services. And Sanwo-Olu is not alone, as I said. We don't know how Tinubu, the president of Nigeria, how he paid his own legal bill. Did he pay from his pocket, or did he pay through procurement? Or did he pay through any other governmental purse? Because let us leave Sanwo-Olu apart for now. But what about Tinubu? What about sitting governors other than Sanwo-Olu? There were several sitting governors that are still in court, that were re-elected, that are still in court. How are they paying their lawyers? Is it from their pockets? How will we know? The undoing of Sanwo-Olu is that the procurement board in Lagos has a website, and he put the matter out there. That is why we are talking about it. That's why the whole country is paying attention to it. But it is easy to assume, and it is difficult to deny, that most people who are in government will use government resources to pay for their legal bills, especially their election petition bills. They may deny it because it has not been exposed like that of Sanwo-Olu. But if you do a thorough search, you will discover that what Sanwo-Olu allegedly did is what all of them does. From Maiduguri to Calabar, that is what they will do. It is because of this kind of situation. That was why many people were not happy that people that won an election are sworn in on May 29, when their petition against their election victory or declaration of their victory by INEC had not been sorted out in the courts. That was why a lot of people were unhappy that President Bola Ahmed Tinubu was sworn in on May 29th. They know that sitting there as the president of Nigeria will give him so much advantage, not only in terms of having governmental resources to hire the best of lawyers. People might argue that Tinubu was a rich man, he was a billionaire before he became governor, before he became president, that he has his own money to pay his bill. Why should anybody suggest that he has to be the president to be able to pay his bill, illegal bill? Don't be too fast in thinking like that. But that was what they said, that Tinubu is rich, he has so much money. Now, when he became president, and we all know, it's assumed, it's believed that Bola Ahmed Tinubu has private jets. Is it not true that Bola Ahmed Tinubu is believed to own private jets? But as president of Nigeria, have you not heard the allegation that Bola Ahmed Tinubu's son was using the presidential fleet. He used it for allegedly for his personal use. He was not an official of government. Why didn't he use his father's private jet? Why didn't he use his father's? Because his father has a private jet. Some say he had about 2 or more before he became president. So why didn't the son use his father's? But he preferred to use the taxpayers funded private jet, presidential jet, to go and watch polo or participate in polo game somewhere in northern Nigeria, allegedly. So don't be deceived by the idea that the person is rich, so he wouldn't have any need to take advantage of his position in public office. No. You don't know, and we don't know how Bola Ahmed Tinubu paid his lawyers, both in Nigeria here and in the United States. But we can say for certainty that Labour Party presidential candidate Peter Obi will pay through his purse, or some people will help him pay. We can be sure with certainty that Atiku Abubakar will pay through his purse, or somebody will help him pay. Since these people are not in office, they are not likely to use taxpayers' money to pay for their legal fees the way that Sanwo-Olu allegedly did, and as was discovered in the procurement details in Lagos State. So you can now see that those who have been clamoring and saying, do not swear anybody in until after the legal processes are finished, so that they can use their personal money to pursue their legal processes. That those people, and I'm among them, that we are right in advocating for it. We are right in seeking for that kind of reform in our electoral system. And it is also important that when we are doing electoral reform, when we are reforming the electoral system, amending the Electoral Act of 2022, to take all these unfolding events into consideration in the amendment of the Electoral Act, to make sure that after the election, 2-3 weeks, the court should be able to set out every matter that pertains to the election before the president is sworn in on May 29. It can be done. That will eliminate the advantage that the president or the governor will have by already being seated in office while the election petition is still ongoing. It is a matter that should be taken seriously, because I believe strongly that what happened in Lagos State, what Sanwo-Olu allegedly did, is not an isolated incident. I can say for certainty that it is a nationwide thing. It's going to be a nationwide thing. If an independent investigation is conducted around this matter, it will be discovered that most governors and the president himself cannot be exonerated from this type of issue. It is common knowledge. People knows it. That you cannot expect that a sitting governor will not use part of the resources of the state to settle his legal bill, or a sitting president. If Nigerians take this matter seriously now and began to demand as citizens that the governors produce the payments they made to their lawyers that defended them at the tribunal up to the Supreme Court, we will be amazed what we will discover. We will discover that Sanwo-Olu is not alone. And this kind of matter did not start today. In fact, I can say for certainty that previous presidents and governors did similar things. So that is why this Sanwo-Olu matter should be an eye-opener for Nigerians on the need to reform our Electoral Act. And in reforming the Electoral Act, any sitting governor or president should be compelled to make public the payments for his legal fees, his or her legal fees, so that we can be sure that it wasn't state money or taxpayers' money that he used to sort out his personal legal problems. And that could be part of the responsibility of the Independent National Electoral Commission. That politicians, sitting presidents, sitting governors should make available the fees they paid to their lawyers to defend them, and to confirm that it is from their personal purse and not routed through the procurement procedure or through any other means that will show that they took the money from the government, but to route it in such a way that people may not understand that it's government that released the money. That should be thought about and enforced effectively. Already we know that in the Electoral Act, there are limits to campaign funding. But INEC even enforcing that? INEC is not enforcing that. INEC is not enforcing that. What did INEC do when they were paying $10,000 for delegates of political parties? INEC were there as observers. What did they do? What did they write in their report? But that's a story for another day. But the important thing is there is a need to reform our Electoral Act in such a way that those in government will not use government money to settle their bills, to settle their legal bills. They should use their personal money to do that, because it's their personal affairs that had nothing to do with the running of the government. That should be done. That is one of the things that the citizens should clamor for and draw the attention of their lawmakers to look into this matter. Because this, like I said earlier, Sanwo-Olu's matter is not an isolated incident. It is nationwide. So it need to be addressed. Then the issue of swearing in people only after all the legal processes challenging their election had been settled should also be addressed. So the election timetable can also be arranged in such a way that there will be at least 3 weeks window for the courts to settle this matter, to settle the election dispute. For example, the presidential election, there is no need going to election petition tribunal or going to the appeal court. Election presidential petition should go straight to the Supreme Court, the way they are doing it in Kenya, straight to the Supreme Court, so that the matter will be sorted out within 1 week. You can see how fast the Supreme Court, when they want to work, how fast they were able to deliberate on Tinubu and co matters. They just presented their team. Before you know it, they have invited the parties to come and for judgment within just a few days. So if they can do that, it shows that the Supreme Court, after an election, within 3 weeks, they can sort out the whole matter that has to do with the presidential election, and also sort out the governorship election matters, so that when that is cleared, people could be sworn in. And not this situation we have today, where sitting presidents and sitting governors will be sitting at top of the resources of the nation and use it to clear the mess they caused in the process of emerging as president or governor. I think that's the lesson I think we should learn from this Sanwo-Olu matter. That's my own takeaway. Thank you for watching this video. And if you are new to my channel, you have not yet subscribed to my channel, please subscribe to my channel. Hit the subscription button, hit the notification bell. When you subscribe to my channel and hit the notification bell, anytime I have a new video, you'll be among the first to know. God bless you. And please don't forget to like this video, because when you like it, Google will rank it high and recommend it for more people. Thank you, and God bless you and yours.